Hi guys, I'm GAURI and I'm an intern at LEXIS and Company. I am a student at Symbiosis Law School, Pune, and today's topic is defense of insanity or mental abnormality under criminal law or under the IPC. We have section 84 of the Act, which talks about act of a person of unsound mind. What does it say? It says that nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable or knowing the nature of the act, etc., act or that he is doing what either is wrong or contrary to law. The words nothing is an offense says there is no criminal liability on a person who is unsound by mind and is incapable of knowing the nature of the act. And this has to be proven by the court. These are not just medical, not just material facts. This has to be proven by the court. And yes, this should be at the time of doing the act. Maybe yes, a person is not of sound mind, but he knows that maybe by taking a knife and slitting it through a person's neck, across a person's neck, it will kill a person. The person knows this, that yes, this will happen. So he will be liable for murder or culpable homicide, which may amount to murder. Alright, so at the time of doing it, he or she should have that character. Alright, next is mental abnormality is one of the general exceptions. And there's this legal maxim that is actus non facit reum nisi mensit rea. Mensit rea is mind, right? So, guilty mind. An act itself is not a crime unless done with guilty intention. Alright, next we have the essentials of section 84. We talked about unsoundness of mind. Now, there can be different kinds of insanity. There can be delusions, hallucinations, there can be mental agitation, annoyance, fury, or even there is sometimes that people walk in sleep. So even that can be there. All right. Uh, Next we have is a very important case, that is state of MP versus Ahmedullah. Here, the Supreme Court held that the burden of proof to prove that at the time of doing the act he was suffering from unsoundness of mind is on the accused. Obviously, the petitioner won't tell that yes, he was suffering from unsoundness of mind. If a person wants to take this defense, he needs to prove that yes, at the time of doing the act, he was not sound and he should not be held liable. There's this another case, that is Sherali Wali Muhammad versus State of Maharashtra. Here, the accused killed his wife and daughter with a chopper. Alright, please go and read this case, it's a really interesting case. Also, under section 105 of the Indian Evidence Act, there is a presumption of sanity on the accused. So that is why the person has to prove himself that yes, I was insane while I was doing the act. So yes, this was all about section 84 of IPC. For any feedback, for any questions, please feel free to use the comment section. Also, this video is strictly for educational purposes. Thank you so much, guys. See you in the next video.